I am joined today by Marta Sznajder, competition and consumer protection lawyer with academic interests focused on European Union law. She's a PhD candidate and she has experience, for example, in working in the Center for Antitrust and Regulatory Studies, University of Warsaw. Welcome.
Hi, thanks for having me.
The 21st century is one of digital globalization. New technologies emerge, but at the same time, corporate giants such as Facebook face serious privacy breach allegations. A few weeks ago, Elon Musk, known as an eccentric owner of Tesla and SpaceX, announced that he bought Twitter, probably the most important platform in the world in terms of international political conversations. These are some strange times. So if you had to describe our digital era in a few words, what would they be?
Oh, a few words might be a challenge to describe them for sure. Firstly, maybe I can say that I can look at these issues from my background and perspective, being a lawyer, especially interested in EU regulatory and competition issues, which are indeed very relevant if you try to regulate these issues. Issues being indeed that there are a few massive platforms who have great power that they accumulated due to, for sure, their great business models, but also to the way in which the digital markets function with the network effect, which means that the more users join a platform, the more users want to join the platform, the bigger and stronger the platform gets. Multi-sided aspects of these platforms, where they're mainly basing their business models on the advertisers on the other side of the platforms, and then users thinking that they're actually using them for free, as they're often claiming to be, while actually there's a lot of data that the platforms are usually extracting and then commodifying for the advertisers to pay for them being there. So these few massive platforms often have so much power that they can be called the gatekeepers of entering this digital environment, as it's very difficult for competitors to set up their businesses and to grow to this extent that they could actually compete with Google, Amazon, Facebook, whatever it may be. And then the consumers don't even often realize that there's a bunch of threats to their privacy, to their data protection, to their consumer rights when they're interacting with these platforms. And then this harm can not always be seen so directly because of the structures of this environment. So there's for sure a lot of legal issues that these business models have created. And the funny thing is that this environment is developing much faster than the legal framework. So when we are stuck on discussing one issue, let's say data protection, on offline or even maybe somewhat online, there's 20 different new challenges that have been created in the meantime that we only see later on. So it's very difficult to regulate these fast-growing environment, and to also see forward what the challenges to be regulated can be. And yes, indeed, the example that you brought up with Twitter is a very interesting case, as on one hand, it can be scary to think that the richest man in the world, who already has a lot of voice on the platform and who has a lot of followers and both fans and adversaries, is now buying the platform, and he has very strong views on what free speech should mean and what this platform should be about. But at the same time, there's already those challenges of what can we really do about this? Surely he should notify this transaction to relevant competition authorities, as one does with transactions of this scale. But at the same time, because his businesses are not really related to media or online platforms or these sort of markets, the current framework that we have in competition law and regulation, not only in Europe, but generally worldwide, it may be very difficult to be able to do anything. Well, the risks to him perhaps changing the way the platform functions, and then the users not being able to use it the same way they have, are there. And this actually, demonstrates how this transaction or potential transaction, because I'm not sure if it's happening in the end or not, because he keeps changing his mind, but demonstrates the risks of what can happen with our data, with the media environments that are also very interesting when it comes to algorithms and the AI that is being present, how it regulates free speech, and how that refers to the basic democratic concepts of media freedom, media pluralism, and such. So this definitely wasn't a few words, but I hope it somehow draws the picture for our talk today.
Yeah, that's great. Yeah, and surely the Twitter topic is an open one for the future. But tell me, because the main topic of our discussion is the occurrence of new digital technologies and their impact on the EU's competition policy. So I think I should ask now, what is competition policy and why is it so important for the European Union to have one?
Right. That's a very good question to start, indeed. So competition law is generally, we can generally define it as a way of regulating the market occurrence. So as a general rule, we have freedom of establishment and free market. When one can set up a business, that business can grow, the business can merge with another business, but there are certain things that this business cannot do because it would harm the competition, which is generally a good thing, because the more competition we have, theoretically, the better prices, the better output, the better quality there is for consumers. So we have this competition policy so that consumers get for the so-called consumer welfare, which is defined by low prices, high quality products, innovation, and so on. So within competition law, we can talk about different ways of different behaviors that are regulated in certain ways. There are things two main things that businesses cannot do. One of them is the anti-competitive agreements, such as, for example, cartels, which is to say that companies cannot, for example, agree on prices that they're going to sell their products to distributors or consumers, because, well, again, this would limit the competition and negatively impact other businesses, which could fall, and then the monopolies could grow and consumers would not have a lot of choice in good prices. And the second type of behavior we regulate in competition law is abuse of dominance, which is a situation where one company grows to a significant extent, has a lot of market power, enough market power that it can act independently from other market players. It can, for example, raise prices or lower prices without really being affected by the market. Because it's so powerful. And while this position of dominance is not necessarily bad, what is bad is to abuse it. So use this position in a way that, for example, exploits competitors, or in the end negatively affects consumers. And then the third type of behaviors that we regulate is merger control. So a situation where we have businesses that are merging, or when one business takes over another business. This is something that before it happens, it needs to be notified. If it reaches certain thresholds of scale, it needs to be notified to competition authorities, which then review whether this transaction can happen without negatively affecting the market. So the first two behaviors we assess after the fact. So we see that there is a problematic cartel or a dominant position that's acting abusively, and then we regulate them. But then on the other hand, there's merger control that we regulate before it actually happens. Sorry, no, go ahead.
Yeah, I was going to ask you, what is the EU's policy towards such big companies like Google or Facebook, and are they perceived by the EU as a threat to the digital free market?
Yeah, so the policy in general is that EU regulates these three, let's say, types of behaviors, and then with the emergence and development of the big digital companies, there's been a lot of challenges in applying this traditional understanding of, let's say, how to define markets or how to measure market power or what sort of behavior is abusive, to translate this from traditional brick and mortar companies to these online environments. So I wouldn't necessarily say that the EU or the Commission that actually is the institution in the EU which handles competition law enforcement that negatively see or immediately sees these companies as bad or as violating the policy. It's more about the type of behaviors that they sometimes employ. So there's already been a few of cases concerning Google and Amazon by the European Commission, where it, for example, have found that certain types of behaviors have violated EU competition policy. Like one big case that was also recently re-emerged is the Google shopping case, where very complicated case, but to maybe summarize it briefly, was that Google was found to abuse its dominant position on the market of search engines and so on, because it was favoring its own shopping products. When someone was searching for a specific product, the first thing that they would see on the Google search were products that were also sold by Google or like through Google's intermediary shopping site. So by employing an algorithm that worked in that way, this could have led to people choosing, or whoever was searching for a particular product, choosing the one that Google suggested first, rather than scrolling through a number of pages to then see something that another page was selling. So this was found to be problematic. And then, of course, Google had appealed. And then late last year, the General Court ruled that in general, it didn't agree with all of the Commission's reasoning, but that in general, it upheld the Commission's decision that this was indeed abusive. So this is a very interesting development indeed to see how this works and how these digital companies can, these gatekeepers actually can then work abusively in a way like that. And actually, a fun fact, a similar kind of theory of harm has been, we don't actually know because the proceeding hasn't ended, but it has been developed or discussed in terms of Polish competition authorities proceedings into, or investigation into Allegro's practices, and whether it's also not like favoring its own things when searching. And kind of a similar behavior was found with regards to Amazon. And yeah, the EU, especially with the current executive vice president, the commissioner for competition and the digital age, has been very vocal about trying to act and to indeed adjust the EU approach to, or EU competition law enforcement approach to these issues, and to make sure that European customers are duly taken care of and such. And yeah, there's been a development with regards to the Digital Services and Markets Act, which both tried to tackle some of the issues that the gatekeepers have been posing, and generally defining that and trying to adjust the way we can apply consumer regulation, online data protection, to some extent competition enforcement in regards to these big companies. But then I think it yet remains to be seen how well these mechanisms will work and to what extent they can actually be enforced.
And regarding the abusive dominance and competition policy, you wrote an article that was titled Unprecedented Judgment of the Warsaw Competition and Consumer Protection Court amending a merger prohibition decision. And you wrote in that article about the controversial judgment that was in Poland that was criticized for its possible political motivations. So could you tell us about the judgment, and is it a threat that the governments can put political motivations behind such decisions?
Right. Yes. So, of course, very happy to talk about this. So the case at hand was the merger prohibition decision. So a situation in which the companies who wanted to merge notified the merger to the competition authority, and the Polish competition authority prohibited the merger, which is already a very rare circumstance. Like because in those merger cases, the competition authority in most cases clears the transaction, so the companies can go ahead and merge. And when it actually finds that that the merger may harm the market, there may be some negative effects, it conducts a longer investigation, and then usually in most cases like that, it will offer some conditions for those companies that will allow them to merge. So that means that they can merge, but they need to, for example, sell some of their assets or to behave in a certain way so that the merger doesn't actually negatively affect the market. That is why the prohibition decisions are very rare. So in that decision, this was of January 2021, in the Agora attempted acquisition of Eurozet, the competition authority did not allow any conditions. It strictly prohibited the merger, claiming that it will negatively affect the markets, mostly for radio broadcasting. And the idea in the decision was that in the very somewhat indirect and distant future, because of the way the markets will be structured after the merger, there may be a risk of harming the competition. And this is what was mainly criticized, because in the way we understand competition law in general right now, traditionally, is that the merger may be prohibited if the analysis shows that there's direct links between the transaction and a negative impact on competition, which is not something that you could really assert from that decision. That was one thing. And then the other was that it was assessing very technical coordinated effects of horizontal mergers in a way that is not really compatible with the general decisional practice of the competition authority, of the Polish competition court, and generally not the way it's been understood in the doctrine. So this is what happened back then. Everyone was, all the competition law doctrine in general was shocked by this decision being so strict and also giving such confusing arguments. This was one thing. And the other is that as there's already been a lot of discussion on the fact that the president of the Polish Competition Authority cannot really be said to be an independent and impartial body, because of the way that they're elected, as this is a position that's directly elected by the government, and the prime minister can take down the head of the Polish Competition Authority at any point. Which obviously means that the president is politically nominated, is someone that the government chooses. And we can also see that, maybe less with this head of the competition authority, but the previous one, which was also nominated by the current government, that they're also often very outspokenly supporting the government in various proceedings. They're, on one hand, they're acting in a way that the government says they are going to act, and then the competition authority follows the government in their actions. But on the other hand, they also implement their policies aligned with the current ruling policy. And you can observe that, and there's also some research done on how it developed since the current ruling party took over in Poland, and how the competition authority has been acting since. So as this is the background for the case, and we can also see that Agora and Eurozet are some of the media actors in Poland that are rather critical of the government. So when you put all of these pieces together, that you have a strong, dependent politically head of the competition authority that obviously steers the work of all of the competition authority in such high-profile case would definitely be something they're involved with. You have a very dubious theory of harm and evidence gathered in the case, and you have a prohibition decision. Well, it all comes together when you think that there may have been some political motive for not allowing this this concentration, because, well, yeah, like there may if a proper competition analysis was applied, perhaps there could have been risks, but this is very, the way the competition authority was justifying its prohibition decision, it's hard to find this proper competition reasoning that would justify that. So this is the what happened last year, and last week, I think it was 12th of May, 2022, the Warsaw Competition and Consumer Protection Court, which is the body that deals with the appeals of the decisions of the competition authority, issued a judgment which was also unprecedented and absolutely groundbreaking, because it not only repelled the decision of the competition authority, but it also amended it using the competence to do a full review of the facts of the case. It said that the merger should be cleared, or not that it should be cleared, it did clear the merger. So after the judgment, well, of course, the competition authority already said that it's going to appeal this judgment to the highest court, and then we'll see what happens then. So the judgment is not operational yet, but the idea is that that the companies should be able to merge, and this shows that in the opinion of the court, the judgment, the decision of the competition authority was wrong, it was a mistake, and well, kind of hints to what I was talking about, so the potential, I mean, the judgment doesn't hint to that, the fact that it happened hints to the fact that this could have been, yeah, some shady political motive behind this decision that lacked legal or economic reasoning. Yeah, and I think that's a very interesting development to see that the court did that, and well, it goes hand in hand with a lot of the academics have been talking about in regards to this judgment. So that's good to see that this civil society can have a say. And yeah, for sure, this case very well illustrates what happens when, or rather what can happen with a rule of law backsliding or democratic backsliding occurs, and what the impact of populist politics on the functioning of a competition law system or the market in general, what it can be. Actually, there is a really good book that my PhD supervisor, Professor Maciej Bernat, wrote about this. So if you're interested in the topic, I really recommend Populist and Antitrust, and the title goes on, but very much, yeah, digs into how the system is changed, both in terms of the institutional design of the competition law enforcement, but also the practice of enforcement itself and what the risks are. And I think, yeah, this case illustrates that very well.
Does it happen often that there are some political motivations behind such competition policy decisions?
I think it's a hard question because you can look at political motives in different ways, right? Like the competition policy, as any other policy, obviously has some deeper, bigger philosophical, political idea in mind. Like, for example, the fact that EU competition policy very much differs from US competition policy is already a political choice, right? So like we in Europe have decided to protect these values. The US has opted for different types of values, so the systems differ. But I think this is so also, for example, with the digital platforms, you can see it very well that there's voices in the debate on how to regulate big tech. There's those voices who say this should not be allowed to be this big. We should break down the big tech companies in general. There are voices on the opposite spectrum that say it's competition on merits, so they should be as big as they want. It's like, as long as they're not doing anything bad in the traditional way, which doesn't really work to apply it like that. But there's that side, and then there's, you know, somewhere in the middle. So these are all political choices when you're, let's say, designing competition policy. And of course, it impacts the way you design or who designs the law, as it always does. But I think the difference is with this, and for example, with the Agora Eurozet case, that the law stays the same, right? But then the competition authority or the courts apply it in different ways. And then, of course, we never know for sure, because no one from the competition authority is going to come out and say to a press conference, say, we made this decision because the government told us to do so. It's more something that you can infer from, well, the general context. But yeah, like I think to answer your question more briefly, it's unfortunately sad to say that there's been more and more situations where you can spot these issues. So for example, in my PhD research, I'm looking into the role of competition law on the media markets, and kind of taking this political context into account more specifically. So besides the Agora case, maybe you've also heard about the merger between PKN Orlen and Polska Press, which also has been very criticized for its political implications, being that PKN Orlen is literally a state-owned enterprise that already had acquired Ruch, which is one of the biggest press distributors, and has now acquired Polska Press, which is a publishing house of like dailies and weeklies, regional press. So now, and then PKN Orlen has gas stations where it also sells press. So it's been argued that it essentially has this structure of wholesale, retail, first the publishing, then wholesale, and then retail distribution of press. And that it can be very dangerous to say that, for example, from now on, they're not distributing or they're not selling on the gas stations press that's been issued by a different publishing house, for example, than Polska Press. Like these kind of things could happen there. While so there's a lot of controversies already in the transaction itself, but then it's also very interesting to see that this decision, clearing this merger without basically any doubts, and not even going into those phase 2 proceedings where the proper, like it's properly analyzed. It was cleared, I think, 3 weeks after the Agora Eurozet was prohibited. So you can see very different approaches to these two cases. And yeah, there's that, for example. But it's not just the Polish issue. This is, for example, also very prevalent in Hungary with regards to media markets, that they have a slightly different competition law enforcement system. But in short, there's also been a massive media conglomerate created through the system of mergers that have been exempted from proper competition review on request of the Hungarian government. and then now the conglomerate has direct ties to the government, and it produces press or media that are fully in line with the government. So yeah, like unfortunately, this is something that happens or that can be spotted, particularly maybe relevant on these more sensitive or well, media markets, I guess, are something particularly powerful and important to the whoever is in charge. So I guess from their perspective, it would make sense to go to have more influence there than, I don't know, on the markets for shopping malls or but even in those cases, you can see, I think this was also a Hungarian example of some issues regarding agriculture and how the government has been meddling in competition cases regarding some agricultural issues. But yeah, I think it's definitely not something that we want in competition law enforcement. But I think politics are there on the background when designing the policy. You're picking your aims and goals and choosing solutions that are in line with what you believe in. But then when you already have the law and then you're enforcing it, you should not follow anyone's orders but the laws. So for sure, the issue of independence is very important. And this is, for example, a different type of EU competition policy, one could say, that there's recently been this directive called the ECN Plus directive that, for example, requires member states to pass laws to ensure a decent degree of independence of their competition authorities. So the EU, to some extent, also aims to regulate the procedural or institutional aspects of, or rather, this is the directive, so it doesn't directly regulate how it works in the countries, but more sets standards for how countries should regulate it. But for example, with regards to Poland, this directive hasn't yet been transposed, even though it should have been in February, I think. So we'll still have to wait and see how this is actually implemented in our system, and whether the competition authority is granted a bigger degree of independence and impartiality, and maybe some safeguards of autonomy, but also accountability. Yeah,
and in order to further amend their competition policy, the European Commission in December 2020 proposed two legislative initiatives and to upgrade rules governing digital services in the EU. And these were called the Digital Services Act, DSA, and the Digital Markets Act, DMA. So my question is, what are they and what do they change on the European markets?
Right. So I had briefly mentioned them before, but I'm happy to elaborate. So I think the DSA's final version has already been passed. And essentially, so that the Digital Services Act mainly aims at regulating platform behavior, accountability, more in regards to consumer protection, while the Digital Markets Act is more focused on regulation as such. So yeah, again, what kind of behaviors platform can do, but more on the scale of the market rather than their interaction with consumers, for example. So both of them aim to general terms enhance the online environment for European consumers. For example, by defining what gatekeepers are, what obligations they have, how they should treat consumers, things like that. I think they were a good step for sure. We're still going to have to see how effective they actually are. And for example, with the if the takeover of Twitter, for example, happens, the commissioners have already talked about how Elon Musk is going to have to comply with the DSA and like the online protection of consumers. But at the same time, yeah, how are they actually going to be implemented? What's the role for national competition authorities? Do they have any role at all in enforcing the Digital Markets Act and so on? These are still the questions that I feel are very much up in the air. But I think it's generally a good trend that the European Commission tries to move forward with these developments in the world, new technologies, and so on. And that, yeah, it fights for the European consumers to create a safer, better online environment. And I think especially the past years of the COVID-19 pandemic, when people were spending most of their time online, interacting with others on social networks, doing their shopping through e-commerce, enjoying TV on some streaming platforms and so on and so forth. This only highlights how big these technologies are in our lives right now, and how desperately they need to be regulated before they harm consumers, who again are not always even aware that they're being harmed.
Yes, that's true. So my last question to you actually is, what difficulties are there and will be there in the future with competitiveness control in the digital markets?
Okay, so I think one of the issues that is there is that, okay, yes, the structure of the market is this is one of the very first challenges that we've noticed, but I think to a large extent it's still present, that the structure of the online market is very different than the structure of traditional markets, because in some ways, because in traditional, let's take commerce as an example, right? So traditionally, if you were to buy something offline, you just go to a shop and buy it, and the transaction would be between you and a customer, and the shop. And the shop could have been an individual business owner or a large company or whatnot, but it would still be a transaction between a consumer and a business. While when you're shopping on a on a large e-commerce platform like Amazon, for example, you're often interacting with not just another business, but you're buying also things from other consumers who are selling things online. So the interaction is actually three-sided, right? Because you have a consumer who wants to buy something, you have a consumer, sometimes a business, but also a consumer who wants to sell something, and then the platform who's operating in the middle of this. And this is still not really tackled, what the role of that platform is, to what extent the platform is accountable, to what extent the platform takes any responsibility for whatever actions of either of the parties. So this is the multi or two-sided structure of the market is has already been an issue, and it seems like it won't really fade away, especially with the fact that there's more and more different ideas and types of businesses that use this platform business model online. The other issue, maybe more related directly to competition concerns, is that the traditional mechanisms in which we assess let's say, abuse of dominance or any like competitive issues are often based on positive prices, for example. So the fact that something is too cheap or too expensive, or just wrongly priced, discriminating someone, so on. Well, as anyone who uses the internet and online platform knows, most of them don't actually require you to pay any money, any positive price for your presence there. So as we already talked about, how their business model in most cases works is that they make money off the advertising who by commodifying the data of the users who are there for free, so that advertisers get their data and apply algorithms that target them with their advertisements. And this is something that to a certain extent can escape competition control, because there's some prominent academics still claim that this is not a competition law issue at all, because without prices you don't have markets. So what are we even talking about? But with the maybe more progressive way of thinking about this, of course there's markets, and of course there's prices. They're just not expressed in money. But then on the other hand, it's difficult to quantify or assess the risks to, let's say, abusing the market for attention. What does that even mean? And then with the question of data being used, there's voices that saying that perhaps this is an issue, but it's not an issue for competition law, but maybe more for data protection law or privacy law. But at the same time, data and privacy law maybe don't have mechanisms as strong as competition law to deal with that. And then on the other hand, these issues are actually what creates these imbalances on the market and what gives them the dominant position. Or so there's a lot of those complicated elements of essentially looking at how, very simple terms, online platforms differ from what we've been dealing with so far, and the risks that are there. And yeah, finding new mechanisms or adjusting the old mechanisms to apply to them, but also using different branches of law like consumer protection, data protection, privacy, and so on, so that they work coherently together with competition law, and that they actually create proper framework for protecting other businesses and consumers.
Thank you very much for this lovely and fascinating meeting. My guest was Marta Sznajder. Thank you very much.
Thank you.